Third way we use this, and Justin, I'm going to kick it to you for this, is when we're actually in court and we're litigating, right? And we're actually having to talk to a jury or a judge, and we're having those conversations, which again, as we said on prior episodes, that's not always reality. That's kind of theater, right? But part of theater is how memorable is it to the juror or the jurist that is hearing what we're saying as they're making their decision as to whether or not our client is guilty or not guilty of the crime. So how can we use the rule of threes to kind of make things memorable and be effective in that scenario?
Absolutely. I'll start with judges first, just because I think juries and judges can go together, but you can also have your judge essentially at the time that you're looking to resolve your case without a trial.
Hmm.
So when you're presenting a plea agreement to a judge, and maybe you've come to the agreement with the prosecutor and both sides are in agreement, but say you had a pretty egregious case. Your client did a lot of stuff, a lot of treatment, a lot of good things to ultimately have the prosecutor agree to a greatly reduced sentence or charges. Sometimes we have to convince the judge to take that plea.
Yeah, that happens a lot. So you are in scenarios, and it's important to understand when you are getting a good plea deal and you're in court to finalize your case and you love that deal and you want that deal, the judge has to bless it. The judge has to agree to it. It isn't just you and the prosecutor in the sandbox. The judge has to ultimately say, that's appropriate. I will take that. And remember, the position of a judge is they're kind of like society's last line.